Hey, everybody, welcome back to the Law&Crime Network. I'm Michel Bryant. This is the afternoon session. Joining me, Terry Rosenblatt, attorney with the Legal Aid Society, DNA extraordinaire. Got all kinds of stuff going on. And I've got Joseph Scott Morgan. I've got Judge Brandon Birmingham. And what we've got are a couple of cases to bring you up to speed on. Let's start out in California. This is the case known as the Hollywood Ripper case. It's the case against Michael Gargiulo. It's Friday, so of course, you know, California, man, you got to chill out, relax, man, take Fridays off. So they're doing nothing in court today, but the jury should get this case on Monday. We're not sure if they've instructed them or not, but they've certainly done the closing arguments. And we're going to, in fact, dip into a little of the closings to give you a sense of what was going on in that case. Remember, we were only allowed in for the opening statements, now the closing arguments, and then for the verdict to come. So let's go in now to some of the prosecution's closing. This is in the Michael Gargiulo case out of California. Cameron's closing argument in the case against Michael Gargiulo, just to give you a little background in the case. Remember, this is a serial killer, serial sexual assaulter. He's up on 2 charges of murder, 1 of attempted murder, and then once he's done in California, he gets to go to Illinois for another case against him. And in fact, the victim in that Illinois case was talked about in this case in California to support the pattern evidence arguments against him. 2 counts of murder and 1 count of attempted murder in this particular case. So DNA, huge in this case, and we heard early on that but for one of the connections, there really wasn't a lot of DNA to link him to all of these particular crimes. So I got some DNA folks here. We should talk about this. First, let me start with you, Terry Rosenblatt. I know you had a very unique perspective on DNA. Give me your 30-second version on what it is you're doing locally in New York about DNA and what your issues are.
So we're in the Legal Aid Society, so we represent people who are charged with crimes who have DNA evidence that the prosecution wants to use against them. Now, DNA evidence in New York is collected in a lot of different ways, but one way where we're particularly concerned about is unlawful collection. So what's happening in New York is that, particularly in New York City, is that the NYPD is indiscriminately collecting DNA from folks who haven't been convicted of crimes and sometimes haven't even been charged with crimes. There are situations where the police have conducted DNA dragnets, where they've set out to collect DNA from, for example, black men in Howard Beach. And that's the police directive. So we're very concerned about that because what happens is that DNA is then put into an index that's maintained by New York City. And that's different than the things like CODIS that you hear about nationally when there are cold hits. This is something where folks who have never done anything wrong could wind up in that index, and that could lead to wrongful prosecutions and wrongful convictions because DNA testing is so sensitive that you can leave your DNA behind just by touching something. So if there's, say, a robbery at my local Dunkin' Donuts and someone touched the cash register and maybe I also touched the cash register, my DNA could show up and get loaded into an index that I should never be in, and I could be falsely accused, or you could be.
So you're basically saying, hey, DNA is great, but you got to get it properly. There has to be some foundational reason to get it in the first place.
Exactly. There has to be accountability, transparency, and reliability for DNA to be a real gold standard science.
Okay. So Joseph Scott Morgan, you know, once you've gotten that DNA, and let's talk about it in the context of the Michael Gargiulo case, we know that there was some finding based on Michelle Murphy's survival of that third attack, and that the blood was matched up from some blood elsewhere. But there's not really a ton of DNA in this case.
No, there's not. And again, as I'd mentioned earlier, in the day that we live in, the day and time that we live in, juries want to see the quantitative findings that DNA brings to bear. Absent those, you're left on, you're left with the work of the detectives, the shoe leather, beating the streets, knocking on doors, and this sort of thing. And also, say, impression-related evidence that we traditionally rely on, things like fingerprints and all these other things that are more interpretive. DNA, again, is a numbers game. It comes down to numbers. But as Terry said, you need to be very careful in this area as far as reliability and how it is collected. And that's one of the things that I teach my students. It's not just going out, with a backhoe and just kind of digging wherever you want. You need a tiny, delicate little shovel to dig these things out. And sometimes the authorities get it wrong.
You know, Judge Birmingham, seems to be a case like this, the Michael Gargiulo case, where you're talking about 2 murders, 1 attempted murder, and then a 3rd murder that doesn't even take place in the jurisdiction, but it's used for pattern evidence, that you as a judge, I mean, it's some major traffic cop work you got to do there to make sure you aren't crossing some inappropriate lines. How tough is that?
Well, it's very difficult, especially when you're talking about extraneous conduct involving crimes that are very similar to the crime for which the guy's on trial. You've got to be able to make sure that the state can prove it beyond a reasonable doubt. You got to make sure that it's being offered for a very specific purpose, not just, hey, this guy's accused of killing somebody else, so he must have killed this person here. It's got to be offered and be able to be proven or tied to a very specific reason in the case. Perhaps it's a similar way that the crime was committed. Perhaps it goes to show identity in a different type of way.
You know, I think this is such a powerful weapon for the prosecution, and I likened it to the Kellen Winslow, the second case where they had all of those sexual assault crimes lumped together. I think in that case, maybe you don't get a conviction if you don't have all of them. Here, we'll see what the jury does with it. Here is a little bit more of the prosecution's closing argument in the Michael Gargiulo case. Boy, the facts to work with here are overwhelming, and you know, for the prosecution, it's how much of this can I lay on this jury. So let me ask you, Judge Brandon Birmingham, how do you think he's doing? You really can pile on here to the point where maybe the jury is almost desensitized to it.
I do like the clear and concise way that he is approaching this. He's basically saying, here are 15 different reasons why these are similar. These are 15 reasons why their cases all these 4 different murders were committed by the same person. 1, 2, 3, 4, 5. Very mathematical, and I think probably very easy for the jurors to follow along.
Terry Rosenblatt here in the studio. You know, DNA is your thing, but in general, this is the prosecution. He's trying to link these what they call pattern crimes. That's his opinion. You know, how does this case stand alone without that evidence?
Well, that's the issue, right? What he was doing, I agree, was a very powerful summation, but that summation only worked because you had to consider all 4 together. And that's what's unfair about a prosecution where you are trying more than one case. That is not the jury's job. The jury's job is not to say, let's look at the stab wounds collectively. It's to say, let's prove each one beyond a reasonable doubt. And I think what the prosecutor did, although it was very powerful storytelling, was not appropriate because it's not asking the jury to answer the question that he actually has the job of proving to them, which is each case individually.
Yeah, these are my homies out there in California, but I really think that rule is so prosecution friendly that maybe almost unfair. Joseph Scott Morgan, you know, you're the guy who's got to get in all that DNA and other forensic evidence. You got a whole bunch here to work with. How do you keep it clean and neat and tidy for the jury?
Well, it's very difficult when you have the prosecutor talking about these speculative aspects, you know, and this goes into the area of things like setting patterns relative to behavior of offenders, serial offenders in particular. I hope that people at home will understand that criminal profiling is in no way forensic science. It's all speculative. And so when you get into these things, you can't go into a courtroom and talk about the profile of an individual in again, I'll use this word, quantitative in a quantitative narrative. It doesn't hold water. So some of this stuff ranges into speculation. You have to be very, very careful.
Yeah, and sometimes you're piling speculation on top of speculation and hoping to get to some conclusion. So there's defense attorney Daniel Nardoni. He's done everything except bring out the old cloak of innocence, that old chestnut. So Judge Brandon Birmingham, I know he gets into more substantive defense arguments here, but you know, he's really laid out, here's the basic law, folks. My guy's innocent. You got to find what the prosecution's supposed to prove. Nothing too crazy there.
Well, he's reminding jurors of their oath. Their oath is to follow a law and render a verdict based not on sympathy, not on prejudice, but on actual proof that they hear in the courtroom. And he's using that because he knows, as obviously following up on the prosecutor's opening statement, that there's extraneous conduct that's going to have been introduced that he does not want the jurors to be persuaded by, not by anger, but he wants it to be a very concise analysis by the juror about what's charged in this case on this indictment, and not to be persuaded by anything else.
Terry, what does he need to get to in terms of substance here? What are the key things that the attorney needs to remind this jury about?
He needs to remind the jury of his client's own humanity. It's one thing to say to the jury, there's this legal concept and it's this thing called reasonable doubt, and maybe you've heard of it before. It's another thing to be able to explain to the jury why they should care about that. And they should care about it because that's the rules of how we treat each other, right? It's our society's rules. The government has to prove their case beyond a reasonable doubt before a jury can come back and say this man committed these crimes. But to do that, you have to have something to tell the jury that is part of your story of whether it's of reasonable doubt or whether it's of innocence. But the story that you can tell in your summation is just as important as getting that concept of reasonable doubt out, because it's really hard for jurors to understand that, especially in a case with details as salacious as this one.
Yeah, and I'm not trying to make this superficial, but let's face it, it's a show. It's a performance for all of the folks in that courtroom. Certainly the stakes are high, but Joseph Scott Morgan, when you're laying out your case, you're telling a story, you're putting on that performance, you want to be able to argue forensics that support your defense, right?
Yeah, you do. You want to be able to present these things so that people understand them, through scientific viability. But the elephant in the room here, there we go, is all of the evidence that has been presented throughout this case. They've seen horrific images throughout this, Michael. And so, taking a look at all of that, how do you diminish what has been done to these people? Because, look, the jurors are human. They can't extricate themselves from those things that they've already borne witness to. It's too horrific. It's absolutely too horrific. And then when they go back into the deliberation room there, some of this might ring true with them, that we have a great legal history here in this country, and that there are certain truths that we hold. But at the end of the day, we've had these people that have been slaughtered. And the trick is, where are you going to find the balance? Yeah,
and I think in a case like this, as with a lot of them we cover that are this salacious, it's almost, it's not officially a shifting of the burden, but it's almost like the jury saying, man, please, defense, give me something, not to find your guy guilty. So one of the ways they can do that maybe is point the finger at somebody else. So let's listen to a little more of the closing argument, see if they do that. Okay, Daniel Nardani at it there with the jury. Two things I like here, Terry Rosenblatt. One is that he drops the celebrity name, Ashton Kutcher. And so I can imagine the jurors going, whoa, wait a minute. It's like my dog. Dinner time? And then he also gives an idea of who else had an opportunity to commit this crime. What do you think?
I think that was a great use of the facts in the case, right? You're right. You have to signal to get the jury's attention, and they have this presence in the trial of Ashton Kutcher, which is a way to wake the jury up and say, now listen, it's all building on what was mentioned earlier, that jurors are humans. They come to this with human experience and real life feelings about what happened. And the other thing then is you say, well, there's an alternate suspect. And you have to be very careful with that, because you don't want to shift the burden. You don't want to say to the jury, well, I want to prove to you someone else did it. What you want to say is, look, if you're wondering if this other guy did it, then that's reasonable doubt.
Yeah, you're planting the seed, and that's use Kutcher to kind of lay out the timeline and help fit that alternative suspect into the timeline. So Joseph Scott Morgan, what do you think? Effective?
I guess that it is. Celebrity name dropping aside, I don't know that he has a lot to work with here, and I know that he needs to shift the blame. And again, the defense is doing their job. They're doing what they have to do. And many times the public doesn't understand this. The public, even my students, many times when I'm teaching them at university, they come in with this mentality that they just want to go for the throat on anybody that's just accused. And you can't do that. You have to understand that we live in a balanced society, and that you have to present all sides here. And so that's what the defense is doing in this particular case.
Judge, I was thinking about this. There are three victims here in this case, and as a defense attorney, you're gonna have one case that's better than another, one defense that's better than another. But when you're giving the closing argument, that's a more tricky balance. How do you handle that?
Well, you argue along the lines that if there are alternate theories, if any of those alternate theories seem reasonable, well, then it's just like Ms. Rosenblatt said, that is reasonable doubt. It is a fine line that the defense attorneys have to walk. You don't want to necessarily commit yourself to one. You remind them that they don't have to prove, as the defense, anything. That's the burden of proof is on the state. But if they're left with these unanswered questions, if they're not convinced, if they have some doubt about what has happened in these particular crimes, then the verdict is not guilty. And that's the overarching theme.
Yeah, it is a difficult balance, and you certainly have to zealously represent all of the people involved here, and you can't kind of lean one way versus the other. And I guess you hope that the message gets through to the jury that there just wasn't enough to find my guy guilty of anything. And welcome back to the afternoon session, everybody. I'm Michael Bryant. Before we move on, I'd like to thank and excuse Judge Brandon Birmingham in Dallas. Thank you, Judge. I appreciate you sticking around to help us go through these cases. Always a pleasure. Good to see you. It looked like a beautiful day there in Dallas. You turned your camera around so we could see Dealey Plaza. Nice day today?
It's perfect, and I'm about to go enjoy it. You guys have a good weekend.
Get out there. Have a good weekend. Thanks, Judge.
Thank you very much.